Hi everyone, I am attorney Lowell James Polinar and I am a project coordinator at Reed Elsevier. As a project coordinator, I am tasked to assist our business partner, Lex Machina, to develop specific practice areas of law to run our legal analytics platform in the US. I choose to practice my profession here at Reed Elsevier and in Lex Machina because I believe that with the unprecedented usage of technology in our legal profession, and fast-tracked by this global pandemic, soon legal analytics will be a key factor to win cases here in the Philippines. As in the United States, where legal analytics is a need for lawyers to strategize in order to win cases, soon that will happen also here in the Philippines. Thank you, everyone.
Hello, I'm Crystal Jane Mendoza, Project Coordinator for the Elsevier's business partner Lex Machina, a legal tech company that provides legal analytics to law firms and companies. As a project coordinator, I am working closely with Lex Machina's project managers in the development of new practice area of the law modules. From project planning and organization, researching and drafting a coding document containing the legal concepts of specific area of the law, to ensuring that the project adheres to a specific quality and productivity framework, and keeping the Reed Elsevier Philippines team informed of Lex Machina's company priorities. I chose to practice my profession in Reed Elsevier and Lex Machina because this is an incredible place where I feel respected and valued for what I bring to the team. Our business partner trusts my work and contribution. They value diversity and inclusiveness as well, treating everyone with fairness and respect. And I also get a chance to work with passionate, driven, and smart people. Reed Elsevier value what matters. They value their people and they promote work-life balance. So what's not to love about this company?
We are proud to be part of RAPH.
Everyone has a place in RAPH. This company cares about and values its people.
I like how we encourage employees to join different activities by sharing their time, talent, and treasure.
We value giving back to the community. And that's why I love Reed Elsevier Philippines.
One of the reasons why I love working in RAPH Manila is we have time to play and enjoy.
It's because of these people. Above all, I think what makes RAPH stand out is how they care and value not just their customers, but also to each employee they have.
And here's one of the reasons why I love working here in RAPH.
I love the flexibility I have to balance my work and home life.
We experience work-life balance through the different engagement activities such as Sports Fest, team building, and the year-end party.
As we say it in the Philippines, it's more fun in REPH.
And of course, you can also meet great people with diverse background and culture.
I am from REPH Manila, and this is why we enjoy our stand-up meetings is because of the people. We are family.
I've been working in Reed Elsevier for 6 years now. And I can say that this is like my second family.
I'm proud to be part of REPH. I'm proud to be part of RELEX.
Every day, I learn from the expertise of the people I have the utmost professional respect for.
It's just simply because I love working with my teammates. And that's it. That's REPH.
I enjoy working in Reed Elsevier Philippines because of its culture and values. Leaders take care of their people, and in return, we develop organically positive and looking forward things.
I feel that Reed Elsevier Philippines has always considered my organizational goals by having prepared me as its promotable talent. I have been through a lot of trainings which I believe led to where I am today.
I feel respected and valued for what I bring to the team. The management trusts my decisions and support my behavior. There is also continuous learning in my job.
The continuous upskilling through mentorship and trainings, and the huge amount of support to the employees by the company makes Reed Elsevier a company of choice.
Hi, I'm Arya. What do I love about working in Reed Elsevier? Work-life balance. Here at Reed Elsevier, we cater work-life balance because we all know we have different priorities at different points of our lives.
Luckily, Reed Elsevier is one with the employees in promoting work-life balance. With 15 circles, everyone will get a chance to discover and pursue their interests even while at work.
Amazing, isn't it?
Hi, I'm AJ, and I enjoy playing basketball. And here at Reed Elsevier, we are encouraged to pursue our interests.
Hi, I'm View. I'm Jade. And we are Shepard's editors. What we enjoy about working here at Reed Elsevier is how the company cares for its employees' welfare by providing an excellent healthcare services and benefits.
I love working here in Reed Elsevier because of the culture. A culture that is employee-centric. Happy employees increases productivity, which results in an amazing team. And this is my team. And we are
Shepard's Legal Editors.
Here in Reed Elsevier, we value what matters.
Broken down and tired of living life on a merry-go-round, and you can find a fighter seeing you, so we're gonna walk it out and mountains. We're gonna walk it out and mountains.
We gon' walk it out. Mountain. We gon' walk it out. Mountain. The silence is quiet, and it feels like it's getting hard to breathe. And I know you feel like I am, but I promise we would take the world to its feet. Mountains, bring it to its feet. Mountains, and I'll rise. The silence isn't quiet, and it feels like it's getting hard to breathe. And I know you feel like I am, but I promise we would take the world to its feet. Ooh, I won't dance, bring it to its feet. Ooh, I won't dance, and I'll rise up, I'll rise like the day. I'll rise unafraid, I'll rise up, and I'll do it 1,000 times again. And we'll rise up, high like the waves. We'll rise up, in spite of the ache. We'll rise up, and we'll do it 1,000 times again.
Hello, everyone, and welcome to today's 2021 Rule of Law Cafe, a COVID-19 special. I am your host for today, Michael Tuazan. At this point, I would like to introduce Mr. Mark Lewin, the Managing Director of Reed Elsevier Shared Services Philippines, for the opening remarks. Mark, you have the floor.
Thank you, Mike. Good afternoon. My name is Mark Lewin, and I am the Managing Director for Reed Elsevier Philippines. REPH is the knowledge services arm of LexisNexis, providing information, analytical, and business services for LexisNexis clients around the globe. It gives me distinct pleasure to introduce the Rule of Law Cafe for today and the larger advocacy of LexisNexis and the Rule of Law Foundation. The Rule of Law Foundation promotes the development of peaceful, equitable, and prosperous communities, specifically through the advocacy of rule of law. Despite the widespread pronouncements of public support for fair legal systems, 57% of the world's population today lives outside the shelter of a functioning legal system. That's about 4 billion people struggling for basic human rights on a daily basis. Moreover, we find that all measures of a community success, mortality, middle-class income, economic growth, etc., are highly correlated with the degree to which people have access to the rule of law. The foundation describes 4 key areas which form the umbrella protection of law: equality under the law, transparency of laws, an independent judiciary, and access to legal remedy. Today's cafe topic is quite timely and focuses on the 4th key area, that of accessibility. Amidst the ongoing pandemic and severe restrictions of normal movement and personal contact, accessibility has increasingly relied on novel mediums of interaction, which before COVID, most people would not have thought possible in a business setting, much less in the legal system. Even this virtual cafe on Zoom and the fact that this has become our normal mode of interaction demonstrates just how much the world has changed and technology is our new medium. So today's topic relates to court technology in virtual trials, and the goal is to empower the legal community to better advance justice and the rule of law through the court systems in our new normal. And after the pandemic, when the impact of innovation and technology will continue to offer greater accessibility to promote the rule of law. I would like to extend a warm welcome and note of thanks to our panelists and welcome all of our audience today. I hope you enjoy and benefit from today's Rule of Law Cafe. Thank you.
Thank you, Mark. So, as an overview for today's webinar, the COVID-19 pandemic has brought many aspects of our economy and society to a grinding halt. Businesses have long been preparing for such situations with their business continuity plans, or BCPs, but the results come in varying degrees of results. On a daily basis, we are bombarded nonstop on media about the adverse effects of the pandemic, but it likewise includes rays of hope and sometimes stories of heroism, spirit of bayanihan, of the daily Filipino helping others in need. However, what is probably not given enough attention in media are the adverse effects of the pandemic on the justice system and the rule of law. Like, what are the measures taken or to be taken, and by whom, to ensure that access to justice, respect for the rule of law, and the health of our legal institutions are upheld? Questions of what sort of strategies and approaches can and should lawyers adopt to ensure that justice is upheld during these extraordinary times of the pandemic. With those in mind, I would like to welcome our distinguished resource persons for today to give some insights on the current and the future of the rule of law in the Philippines. Please welcome Justice Jose Midas Marquez of the Philippine Supreme Court, who is the incumbent court administrator since 2010. And just to give some career highlights for Justice Marquez, he's also the spokesperson and chief public information office of the Supreme Court of the Philippines, former chief of staff of Justice Renato Espuno, and he likewise served under different key roles in the offices of Senior Justice Jose N. Bellosillo, Senior Justice Amofina Melencio Herrera, and Justice Abraham F. Sarmiento. He is likewise a professor and lecturer in distinguished educational institutions such as the Philippine Judiciary Academy, Centro Escolar University, School of Law and Jurisprudence, Pamantasan ng Lungsod ng Maynila College of Law. He likewise served as committee member and consultant on different bodies such as, but not limited to, the Judicial and Bar Council, the Philippine Judicial Academy, for the revision of the rules of court, virtual hearings, electronic testimony, small claims, data privacy, enhanced Justice on Wheels, Judicial Reform Program. Notably, he likewise is an author with several publications going with national publication releases. He's the author of The Constitutional Philosophy of Philippine Jurisprudence, the writings of Senior Associate Justice Renato Espuno. He's likewise the author of League of Life, Love and Law, a biography of Senior Justice Jose Bellosillo. He likewise co-authored Effective Litigation and Adjudication of Election Contests, Fundamentals of Nursing Law Jurisprudence and Ethics, Omnibus Election Code, with Rules of Procedure and Jurisprudence in Election Law, and selected the opinions of Senior Associate Justice Emuerfina Melencio Herrera, the career jurist. He is likewise the editor of Puno Justice and Puno Speak, and last but not the least, project director for the Blueprint of Action for the Judiciary Supreme Court Printing Press. And of course, our second resource person for today is the Honorable Judge Reynalda H. Estacio Montesa. She is currently the presiding judge of Branch 46 of the Regional Trial Court, which serves as a special commercial court and cybercrime court. And just to name a few of her career highlights, she is also a lecturer in training on the following topics: Advanced Judicial Training Course on Cybercrime and Electronic Evidence for Judges, Prosecutors, and other judicial offices of the Pacific region; Introductory Trainings of Trainers, course on Cybercrime and Electronic Evidence for Judges, Magistrates, and Prosecutors of the ASEAN region. She is likewise a participant in the Data Focus 2018, an international conference on digital evidences. She is likewise a presenter and participant in the 8th International Organization for Judicial Training Conference. And last but not the least, Advanced Judicial Training on Cybercrime and Electronic Evidence for the Magistrates. Our third resource person for today is Attorney Marlon Valderrama. He is the managing partner of Valderrama Law Office, specializing in multiple fields such as, but not limited to, civil and criminal, immigration, corporate, investment, tax, labor, IP and telecommunications, family law, energy, mining, and environmental laws. He is likewise the president of Lex Prime Holdings Limited in Singapore, founder and CEO of Lexmeet Incorporated, and a legal consultant for the Angat Hydropower Corporation. He is likewise the founder and CEO of eLawyers Tech Online. and previously served as Associate Solicitor in the OSG, a legal research in the PCGG, Corporate and Legal Officer, Hexagon Group of Companies, and Legal Officer for the ASEAN Pacific Group of Companies. Last but not the least, our resource person for today, Attorney Jed Sherwin G. Uy, is the court attorney and e-court project manager under the Office of the Chief Justice of the Supreme Court of the Philippines. He is a certified security professional, a CompTIA A+ certified, Access Data Certified Digital Forensic Examiner, a Celebrite Certified Mobile Forensic Examiner. He is likewise the lead in the deployment and implementation of the Philippine Judiciary 365, which is the Philippine Judiciary's official electronic communication platform and modern workplace solution. He likewise served as an international expert and consultant for the Council of Europe Cybercrime Program Office and OIC Director in the Department of Justice Office of Cybercrime. He is likewise an investigator for the U.S. Homeland Security investigations in the U.S. Embassy in Manila, and last but not the least, digital forensic investigator for the National Bureau of Investigation. To our esteemed panel members, welcome to today's webinar. So, to jumpstart the discussions today, we'll be discussing the impact of COVID-19 has had on justice and the rule of law, specifically in the Philippines, and the mitigation strategies that the bench and the bar have taken to minimize the fallout on our legal institutions. We'll be going through 4 different topics, spending around 12 minutes on each topic, and have Q&A sessions at the end. Please place your questions in the Q&A box that's at the bottom of the screen. So for today's topics, the 4 topics are the impact on the rule of law and protecting the most vulnerable, care of Justice Marquez; the impact on the courts, care of Judge Montesa; the impact on the most vulnerable, care of Attorney Valderrama; and the last, leveraging technology to strengthen the rule of law, care of Attorney Uy. So without further ado, let's get started. So for the first topic, the impact on the rule of law and protecting the most vulnerable. As mentioned earlier, COVID-19 pandemic has disrupted every aspect of our lives. The pandemic has spared nothing and no one. In this regard, there are very limited media coverage on what steps were taken by the Supreme Court or will take in the future to effectively adapt during these changing times to ensure the wheels of justice remain in constant motion and the rule of law maintained, if not further strengthened during these unprecedented times. Through our resource person, we will know what are the plans of the Supreme Court post-pandemic to ensure any significant disruptor like that of another global pandemic be mitigated in relation to the promotion of the rule of law and accessibility of the courts. This will likewise include possible plans and steps that need to happen to ensure that the rule of law continues to subsist under the vision of the new normal. This will include ideas on what sort of institutional changes, if any, would be needed. To help shed some light on this topic, I now turn over the virtual floor to Justice Marquez. Justice Marquez, you have the floor.
Oh, thank you, Mike. And I'd also like to thank Mark for this opportunity to join you in this Rule of Law Cafe. Let me also greet my co-speakers or discussants for this afternoon. Of course, Judge Nelda of our Regional Trial Court of Manila, Attorney Sherwin of the Office of the Chief Justice, Attorney Marlon Valderrama, and also our fellow lawyers and students of law who are with us this afternoon. Magandang hapon po sa inyong lahat. Before the onset of the COVID-19 pandemic in March 2020, the court tiptoed in allowing the pilot testing of remote testimonies of persons deprived of liberty through video conferencing hearings. The court was steeped in tradition and held back by precedents. It grappled with serious constitutional issues, among which is a constitutional mandate that the accused shall enjoy the right to meet the witness face-to-face, and our rules of court, which entitles the accused in all criminal prosecutions to be present and defend in person by counsel at every stage of the proceedings. In the guidance on the use of video conferencing technology for the remote appearance and testimony of certain persons deprived of liberty in jails and national penitentiary, approved in June 2019, the court required that the remote appearance and testimony of an accused in a video conference proceeding shall closely resemble his or her otherwise in-person courtroom testimony and experience. The court adopted international case law, which declared that face-to-face confrontation during trial is a preference that must occasionally give way to considerations of public policy and necessities of the case, and where the reliability of the testimony is otherwise assured. The court was also very strict with the technical and operational specifications as it prescribed minimum requirements for video conferencing equipment, which were provided both for the courts and the jails. Video cameras were placed in such a way as to cover the same image the PDL at the remote location would see if he or she were physically present in the courtroom. Microphones were connected to an audio processing device that provided echo cancellation. Audio speakers were directly connected to the audio system to reduce latency and improve sound quality, and video monitors or screens were in high definition and large enough for everyone to clearly see the video image, which should be as close to life size as possible. Back then, the pilot testing of virtual hearings was limited to 22 branches and only between two venues, the Davao City Hall of Justice and the Davao City Jail, which were connected by radio frequency transmitted between two antennas in the two venues. That was until COVID-19 swarmed a few months later. In response to the current pandemic, which prevented many of our trial courts to remain physically open, the Supreme Court eventually provided all our 2,600 trial courts with the Philippine Judiciary 365 accounts, which have email applications for their respective email accounts used for online filing and transmission of documents, and a video conference application for hosting video conferencing hearings. Today, as we continue to deal with this dreaded virus, our courts, with hardly any IT training, conduct video conferencing hearings on all matters pending before them in both criminal and civil cases, whether newly filed or pending, and regardless of the stage of trial. From the Davao City experience, which only allowed 2 locations, there can now be as many locations as there are parties attending the hearing. Both the public prosecutor and the public defender can appear remotely from their respective residences, while the PDL appears from the jail. The judge, on the other hand, can host a hearing and preside from anywhere in the country, and even the general public can observe our online hearings. As of July 2, 2021, we have had some 397,605 video conferencing hearings nationwide, with a success rate of 87.75%. 31,703 out of the 93,254 PDLs have been released through video conferencing hearings during the same period. We have also rolled out the e-warrant system nationwide, which fully automated the issuance of arrest warrants by our courts for a speedier and more effective service by our law enforcement agents. The courts upload the arrest warrants they issue in a portal which can be accessed and thereafter updated by the police nationwide once the arrest warrant has been served. This operates as an online database of issued warrants, providing real-time updates on the status and specific actions taken by the police. Once the warrant is served, the issuing court will be automatically alerted and can immediately issue the commitment order. This is a work in progress as we will include other law enforcement agencies like the NBI and the Bureau of Immigration. In an instant, we saw litigation transformed by technology with the least possible means and infrastructure. Through electronic transmission of pleadings and virtual hearings, PDLs are being released from detention, some provisionally, some acquitted for good. Violence against women and children cases are being heard. Search and arrest warrants are being issued, and applications for temporary restraining orders and injunctions are being addressed. And we are not stopping there. With the guidance and direction of Chief Justice Alexander Desmundo, the court will soon launch the e-payment solution to enhance its processes of assessment and payment of court fees. All court fees may now be paid online. No need to personally go to the court or bank and queue. Filers can pay court fees from their residences and offices, or even while vacationing in resorts, using credit cards, bank transfers, and digital wallets. We will also soon roll out nationwide the electronic raffle. No more raffle days, as raffle cases will be done as cases as filed. At present, except in courts and e-court stations, which is only a handful, the raffle of cases are scheduled, and during scheduled days, the raffle of cases are done manually. With the e-raffle or electronic raffle, there will be less human intervention, and our cases will be automatically raffled once on the same day that they are filed in court. These are just some of the technological innovations that our court will be coming up with in the days or months to come. I think Attorney Sherwin will be saying more on that. No? And so let me not overlap on his discussions. No? Maybe I should stop there and give the other speakers a chance to tell us their respective experiences. No? Of course, especially Judge Montesa in behalf of our judges, no? Because these innovations are actually initiated, no, by the Supreme Court. And we were hoping that all, because also of time constraints, no? With hardly any coordination with our courts and the members of the bar, we rolled this out, and we were hoping that they will all be able to cope with our initiatives during this pandemic. Thank you.
Thank you, Justice Marquez, for those updates. Those are really, really appreciated. For topic number 2, the impact on the courts. So working under the same premises as earlier mentioned, with courts being forced to close for days or weeks during those closures because of local COVID-19 infections, which resulted, unfortunately, to further delays in court proceedings that sometimes result to the detriment of the party litigants. Judge Montesa, perhaps you can describe the impact of both the pandemic and the lockdowns, and how has the trial court responded? It would be very interesting to hear how the courts have adjusted their processes to accordingly adapt and manage social distancing measures, including keeping everyone safe during the pandemic. Also, what are the challenges you have observed being faced by practicing lawyers and party litigants amidst the pandemic? Other courts in Asian region have been leveraging technology and are conducting hearings online. What has been the experience of our courts with respect to that? Generally speaking, what has been the impact of these measures taken by the judiciary, and what are the implications of a lockdown on our courts and the continued promotion of the rule of law? Is this temporary, or do we expect to see consequences that subsist for much, much longer? With those in mind, I now give the virtual floor to Judge Montesa. Judge Montesa?
Hi, good afternoon. So taking off from what Justice Marquez said, I think the philosophy that the Supreme Court is following now, taking from Dr. Michael J. Ryan, an epidemiologist from the WHO, he says, be fast, have no regrets. If you need to be right before you move, you will never win. So I think that was one of the thrusts that the Supreme Court had in a span of 3 months from the time that the lockdown was declared in March of 2020 up to May 2020. The Supreme Court has issued several circulars adjusting to the impact of the pandemic to the courts. I think we're one of the sectors that were mostly affected by the pandemic, as we had to adjust our hearings and of course the physical appearance of courts and how we are to maintain the safety of not just our employees but also the litigants. So let me backtrack a bit. The first circular that was issued in March uh, saw the rolling out of the official email addresses of the courts. This is to address, at least during the time that the courts were in lockdown, the electronic submissions of electronic filing of criminal complaints as well as information. So it was allowed that these are to be electronically filed with the courts. Remember, there are also applications for bail, and these were also entertained and allowed to be submitted electronically for those who are applying for bail and have cases that are pending in court. Then, of course, we also saw the scheme of a judge on duty or a justice on duty, where remember during the lockdown, we were not allowed to go to court because courts were physically closed. So the Supreme Court adopted a scheme on the judge on duty, where in a particular station, like for example in Manila, we would go on duty for a week or maybe for 2 weeks, and we would be the ones acting on urgent matters. For me, since I preside over a specialized court, then I would frequently go on duty because we're just two in Manila who are presiding over a specialized commercial and cybercrime court. Then after that, I think the Supreme Court went into the direction of um, seeing to it that the PDLs, that the cases of the persons deprived of liberties were given attention to. So sometime in April of 2020, we were asked to conduct an inventory of our criminal cases so that we are to determine what are the status of these persons who are presently detained, and if we can actually extend some assistance insofar as those who have served their sentence and issue the necessary release orders. And again, in April 27 of 2020, this started the pilot testings of hearings of criminal cases under what Justice Marquez said, the video conference hearings under the Microsoft Office 365, which were given to the courts. We were all given licenses to use that particular application for also for our official email, which is the Outlook application, and for the Microsoft Teams, where we are to conduct our video conferencing hearing. But during that time, in April of 2020, the instruction given to the courts were just to hear PDLs only on urgent matters. And it was only in May 14 of 2020 when the court authorized the courts to hear all kinds of cases, whether criminal or civil, um, through video conferencing hearings. Now, in terms of handling of cases, it's really difficult, like just like anything new. It usually is met up with a lot of criticism, some with hesitance, some with apprehensions, because we were not used to hearings online, and not everybody is comfortable using the computers, especially our more matured judges. I wouldn't want to call them old, but mature judges. There are some who would actually be resistant to this particular change. But I think the end goal is the question that we have to answer is how do we continue dispensing justice amidst this pandemic? And this video conferencing hearing is a way that the Supreme Court and the courts, the trial courts, would be able to continue the cases that are being tried before face to face. Insofar as I remember, during the pandemic, at the height of the pandemic in April, I was called upon to hear an application for search warrant. And as you all know, an application for a search warrant cannot be heard online. So I had to go to court and actually hear that particular search warrant, despite my apprehension of going out, because that was just the height of this coronavirus spread. But when I went to court, I just asked my staff, of course, minimal staff, because I don't want your staff to be exposed. At that time, since it was April, we didn't have any idea yet on how we're going to tailor fit our courts. Just like, how do we make it, it can you say it COVID friendly? But at the time, I didn't have any idea yet. There were in our chat groups or in our associations, there were proposals of installing acrylic barriers for our restrooms. There were proposals of installing barriers between the litigants and the court staff. So it was very difficult because, of course, it entails expense, and what will be the best style, or maybe would it be just me having the barrier, or would it be, it's very difficult to actually design a court in this to be COVID friendly, because remember, the court is designed itself. The courtroom is designed for an exchange of opinion, an exchange of arguments, and it's really difficult when you put a barrier in between, because it makes the case more or less not really impersonal, but you now have a difficulty of expressing your communication, especially wearing masks and wearing all those shields. So in my court, I installed a glass barrier, not an acrylic one. I installed a glass division between my court staff and the litigants. I installed several microphones because I know the moment that there are barriers and lawyers are wearing masks, they would not be able to hear. We would not be able to hear each other. So what I did was I installed a sound system with complete amplifiers. I installed maybe, I think, 6 microphones. I made sure that my courtroom, one lawyer has his own table, no sharing of tables. Then I actually purchased online several stickers saying wearing of mask is mandatory, or the seat, just sit here, you're not allowed to sit anywhere. And if my court, when you put a barrier, it's not that big anymore, so it becomes smaller. So the people now that you can cater is relatively very small. So remember, we're instructed to do social distancing. And what I did now was, not like before, that pre-pandemic, you can just entertain everybody inside the courtroom. When you start at 8:30, all the cases that are calendared for the day, all the lawyers will be inside and all the litigants will be inside. But now we cannot do that. What I did was I scheduled them on an hourly basis. So unlike before, that you schedule them all at 8:30, and then it's up to the court what time they will be called. It's just an 8:30 standard start of the hearing. But now what I did was, if there are 4 cases set in the morning, then they would be sharing from 8:30 to 9 maybe, and then the other case would be called at 9:30. Then the other case will be called at 10:30, and then another case will be called at 11. Because that's how I can adjust to people not crowding in the hallway and in the courtroom. And at the same time, in the courtroom, you limit the appearance of people to just the lawyers and the litigants. I think that is for the trial courts. That is one of the most difficult part. For the video conferencing hearing, I think the challenge really is internet connection. So even though we have all these Teams applications, and even though the Supreme Court now has provided us with all the internet connection, we know that generally in the Philippines, our internet connection is not that stable. So though the court has strong internet connection, some of the parties may not have strong internet connection. And the moment, especially in criminal cases where we're dealing with police officers and witnesses, that's a consideration that we have to make. And the moment that one of your witnesses is not able to join because of some technical difficulties, then I think that's a setback, because you have to reset the hearing unless there's another witness that is available. But the courts have pretty much adjusted well. We encounter difficulties during the first part. As I said, it's very difficult to just shift the minds of people from physical to online because not everybody is tailor made to. Not everybody is welcoming of that particular innovation now. Personally, I like the online setup. I appreciate the efforts made by the Supreme Court through the efforts of our former Chief Justice Peralta and of course our court administrator Justice Marquez. They have addressed the problem very well. It's just that that's really sometimes you cannot um, you know expect everybody to just take it in all at the same time. But I think now that we see the benefits of an online hearing, because now if we ask permission from our court administrator for some exceptional circumstances where we cannot go to the office, we are allowed to do our hearings at home. And in that particular instance, then you don't have to reset your hearing, but you can still proceed. I think the most important thing is that cases are proceeding, cases are running, cases are being called, cases are being disposed. Actually, if if I'm not mistaken, during the pandemic, and I think Justice Marquez will agree with me that we have a lot of PDLs that were released during the pandemic, despite the hearings being conducted online. And I think that is one of the success that can be bragged upon by the Supreme Court as well as the trial courts, because it just a testament that we did not stop, we did not let the pandemic hamper that particular effort. So I think it's just a matter of being able to accept that this is the way forward. Um, if you're asking if this is permanent, I believe this will become permanent. This will become a part of our judicial system. The Supreme Court has even released the rules on video conferencing hearing, and I do hope that if we go into a state where we go back to the normal already, I still believe that the Supreme Court will still allow us to do this video conferencing hearing. So that's my sharing for today. Thank you very much. I hope I was able to at least give my some insights on how the courts were able to cope with the impact of the pandemic.
Thank you, Judge Montesa. And those are very interesting and admirable steps you have taken to address the challenges you have faced in your particular court. Now we have heard both from the bench. Now let's give some time on the bar. For topic number 3, the impact on the most vulnerable. Perhaps well known to everyone that because of the pandemic, time and time again, as earlier mentioned, courts were forced to close down due to local COVID-19 infections. These closures would, last for a few days, sometimes for a few weeks. These in turn resulted to cancellation of court hearings and prevent quick access to the courts and justice. This one goes to Attorney Valderrama. Attorney Valderrama, can you describe the impact of both the pandemic and lockdowns to the legal profession? Generally speaking, what has been the impact of the pandemic to the profession? How has it changed the legal profession, and what can practicing lawyers do to help them adapt under these circumstances and continue to provide the essential legal services required? What recurring or unique challenges are faced by practicing lawyers today? I now give the floor to you, Attorney Valderrama.
Hi, good afternoon to all of you, to LexisNexis and Reed Elsevier, to my fellow panelists, Justice Jose Maidas Marquez, Judge Reynalda Estacio Montesa, Attorney Judge Sherwin Oy, and to all attendees, good afternoon to all of you. I am here as a private practitioner and a legal tech founder. I would like to share to you my PowerPoint presentation. This is my humble presentation to explain to you what are the challenges that we experience during the pandemic and the lockdown. This is from the point of view of a practicing lawyer and legal tech founder surviving COVID-19. Before anything else, getting ready is the secret of success. That is Henry Ford. But when COVID came, many of us are not ready, including us lawyers. So the impact of COVID-19 to private practitioners is really hard. With ECQ and closure of the courts and government agencies, the private legal sector was one of the hardest hit by the COVID-19 pandemic. The inability to attend hearings that led to significant drop in the billable hours or appearance fees of the lawyers. Lack of new legal project or matters because of the economic downturn or uncertainty in the economic outlook of the country. The limited capacity to deliver because face-to-face consultation and face-to-face meeting is no longer allowed. Okay, and due to unpreparedness or lack of capacity of lawyers to deliver billable services. I identified 6 experiences as a private practitioner that impacted our ability to render legal service during the COVID-19 pandemic and during the lockdown. Number 1 is getting new clients. Number 2 is consultation and representation. Number 3 is providing legal documents to our clients, the notarization of document, the management of our law office, and the use of web and technology in general. One by one, I will discuss to you the effect of COVID-19 pandemic and the lockdown to us, private practitioners. New clients is the lifeblood of a law firm or a lawyer practicing in private. Lawyers without website or social media were not able to cope up because they were not able to meet new clients face to face. Those lawyers they use social media to market and get new clients. So natuto na yung mga lawyers how to use social media to market and get new clients. Then there's the online legal services marketplace platforms like Lexmeet that help lawyers to thrive during the lockdown. They were able to get new clients and were able to render legal consultation services to those who need legal advice. The rise of TikTok lawyers and YouTube bloggers who became content creators. They provided up-to-date legal information with respect to the current rules on ECQ, as well as helping them how to cope up with the stringent application of the ECQ rules. Lawyers also became aware of SEO, or the search engine optimization, social media ads, and the need for website. So these are the ones that we were able to learn during the pandemic. Without the technology, we're not able to thrive. But with this, we are now realizing that we need to grow and learn these things. How about consultation and representation? With the ECQ and the COVID-19 pandemic, face-to-face consultation stopped and online legal consultation was used by lawyers. Video conferencing became the norm to deliver legal advice and assessments. Web and mobile applications for online legal consultations became popular. Appearances in courts are mixed with video conferencing and in-court proceedings. Legal documents. So now, since physical exchange of documents are prevented lawyers from doing it, email exchanges between lawyers and clients became prevalent during lockdown to cope up with the demands of legal document preparation. Use of document editing collaboration tool was widely used, such as Google Docs, etc. File sharing apps like Google Drive or Dropbox became popular to lawyers and the clients alike in transmitting and sharing voluminous documents. Use of digital or electronic signature is started among lawyers and clients. Notarization of legal document was also a problem during the first phase of the ECQ or the quarantine, because the processing of legal document needing notarization was put on hold due to limited mobility by reason of the lockdown. With the prompt solution of the SC, the Supreme Court promulgated remote notarization rule, paved the way for solving the problem of notarization during lockdown. However, for us private practitioner, I think it is not enough. There's a realization that full digital remote notarization of electronic document should be promoted by the Supreme Court, such as the recognition of digital signature in a digital electronic document. Law office management. Law firms who are dependent on physical case files suffered hard time in retrieving documents during lockdown. Imagine, you have 100 cases that you are looking at, and all of those are in your office, and now you wanted to work in your house. So all of those case files are being brought to your house just for the purpose of studying it. Work from home arrangement with lawyers and law firm staff became ordinary. Digitization of law firms' case files started as a knee-jerk reaction to the inability of law firms to access them during lockdown. Cloud-based legal management software became valuable and convenient monitoring tools for managing partners. Using web and technology is really helpful to us lawyers, most especially during pandemic. Lawyers are now compelled to deal with clients using different mode of digital payments such as GCash, online banking, crypto payments, etc. Document scanner is now the friend of every lawyer in private practice in order to submit pleadings, process legal documents, among others. Internet accounts, either email, social media accounts, and VoIP telephony account is now a must among lawyers. So by the way, VoIP telephony account means Zoom, Google Meet, etc. Okay. Lawyers' websites are now deemed necessary to market services during pandemic. So we experience so many tech challenges of lawyers. There is the problem of tech know-how in video conferencing, not only with the lawyers but also with the clients. So we are now duty bound to inform our clients how to use the Supreme Court mandated video conferencing tool. Also, it's a problem for us lawyers, the slow internet signal and an inappropriate gadget and equipment. Staffs are also unfamiliar with technology. The unwillingness to change or adapt with the new normal. And we are also afraid of the tech, hacking, and the security of the internet, which makes the use of technology during the pandemic amplified. How did I survive? In 2010, I started to make an e-lawyering website that I use for my own law office. So from 2010 up to now, I am using this to attract clients. So this is one of my way how to survive in getting ready about with this pandemic. Okay. Also, I have an e-lawyering platform called Lexmeet, wherein I was able to have consultation with online consultation with clients using VoIP, using Lexmeet. It's a mobile and web app that that many are using. We already have 850 plus lawyers that are onboarded in this platform. So we're able to help those lawyers who have the tech know-how how to use this to get clients from this platform. Also, in 2013, I was able to start a project, a cloud-based legal management software called eLaw Solutions app. In 2015, I was able to finish that software. And since 2015 until now, I am using it in my law office. So because of the COVID-19 pandemic, I was able to realize that I am ready for this kind of problem or challenges, because in 2015 I was able to digitize all of my case files and put it in my cloud-based legal management software. And at the time of the pandemic and lockdown, my staff and I didn't have a problem accessing those files because they are already in the cloud. And now, since the court is implementing the e-filing of pleadings through email, it's now very easy for us to digitize incoming court orders and adverse parties pleadings. What's next for Filipino lawyers? Well, getting ready is the secret of success. The lessons of the lockdown and COVID-19 pandemic is valuable to us to get ready. My proposal as a private practitioner and an advocate of legal techs are this. Legal tech and online court rules subject must be taught in law schools. Court must have an online presence for litigants and lawyers to check information, appointment system, and calendar of cases. An electronic filing of pleadings must continue to have innovation. We already have that, but we must continue to innovate. MCLE should also include training tech-challenged lawyers to cope up, and an intergovernment agency for legal tech innovation to further improve electronic access to justice and administration of justice. Thank you. That's all for my presentation.
Thank you, Attorney Valderrama. It is quite interesting to note that you're actually ahead of the game, at least 5 or 6 years even before the pandemic struck. You were already leveraging technology in your own practice. And one common theme across the 3 resource persons we've had so far is technology. And for topic number 4, we will be discussing technology to promote the rule of law. It is great to hear that the Supreme Court has taken concrete positive steps in addressing the challenges faced by both lawyers in practice and the trial courts, as earlier noted by Justice Marquez and Justice Monteza, or rather Judge Monteza and Attorney Valderrama. In this regard, Attorney Uy, perhaps you can provide the current technology solutions already available for both the legal practitioners and the courts. How can these technologies further promote the rule of law in the country? Considering that a good number of litigation practitioners and court judges were born and bred on a face-to-face litigation format, and with some not being tech savvy, can you likewise discuss the ease of use of said technological solutions and how reliable these technological solutions are? I now give the floor to you, Attorney Uy.
Thank you very much, Attorney Mike. Good afternoon, everyone. Magandang hapon sa ating lahat. And thank you for having me. It's a great pleasure for me to be here joining Justice Maidas, Judge Nelda, and Attorney Marlon in this webinar. First and foremost, gathering from what has been said already by the previous speakers, the rule of law and its promotion means that despite the system's imperfection, we try to make the world a better place where we have equal opportunities for all and where justice can actually be served. In other words, promoting the rule of law means that despite some flaws, we have a chance to efficiently adapt to new challenges as we continue to strive for the better. And in light of facing the present challenges, we persist to come up with innovations and find solutions for the proper administration of justice. And it is worth noting that one of the twin innovation agenda of Chief Justice Alexander Gasmundo, and he has been mentioning this since his JBC interview for Chief Justice post, and even during the recently concluded IBP National Conference, that is to utilize technology as a justice tool, a means like any other to reach those who need it the most. So at present, the court has invested in a modern workplace collaboration solution. And I want to emphasize that because it is a modern workplace collaboration solution, not just a video conferencing tool or platform, but a modern collaboration solution, which now provides courts the facility to receive electronic filing of pleadings and other court submissions securely. to hear and decide cases via video conferencing, to allow parties to present their arguments and evidence remotely, subject, of course, to certain conditions and safeguards, and to automate certain rudimentary admin processes or tasks, to quickly organize court calendars, and to quickly collaborate among court staff and manage their tasking or assignments. So as part of the case decongestion program of the Supreme Court, and following the revision of its internal rules, we'll be launching in the next few days a case monitoring dashboard, which will allow the Chief Justice and the Associate Justices of the Supreme Court to intelligently visualize data and monitor the aging and disposition of cases in compliance with the 24-month rule prescribed by the Constitution. We will also be launching a system which will be pilot tested first here in the Supreme Court to allow the use of digital and electronic signatures where QR codes will be embedded to allow the public to verify the veracity of decisions, resolutions, and other court issuances online. Apart from this, the court also partnered with a local digital bank to develop an e-payment solution, which will eventually allow litigants to have their court fees assessed online and to pay court fees online using various modes and channels of payment, such as credit card, online banking, digital wallet, among others. This e-payment solution will be first introduced in the upcoming bar examinations 2020/2021, where bar applicants may submit their bar applications online and immediately pay their bar examination fees also online. We are also discussing the utilization of artificial intelligence, or AI, for legal research, which will increase and widen the access of our judges, court lawyers, and legal researchers to various legal resources, and also aid them in drafting decisions and other court issuances. The use of AI is also being discussed in preparation of transcript of stenographic notes, or TSNs. AI is also being discussed for purposes of public assistance chatbot, which would include assisting the public in filing small claims cases where lawyers are prohibited to appear, and so much more. With regard to electronic notarization, the court will soon come out with technical standards that will be used to gauge and accredit the different electronic notarization platforms available, instead of focusing on just one single provider for all. And of course, one of the major ICT projects in the pipeline is the eCourt version 2.0, which will provide a unified, comprehensive, intelligent case management system for the entire judiciary, covering cases filed from the first and second level courts all the way up to the Supreme Court, covering from the filing of cases up to the finality of judgment and execution. With regard to the second point, where a good number of judges and litigators are born and bred on a face-to-face litigation format, let me say this. In any transformation, whether it be digital or otherwise, as long as there is change, there will be resistance. Resistance to change is a normal human reaction, but change is inevitable. Times have changed and technology is advancing in an exponential pace. So the judiciary and its stakeholders must likewise adapt to these changes. We must transform our ways to be more responsive, efficient, and effective in addressing the changing demands of our society. And we are also seeing change in the demographic landscape as digital natives are increasing. As Justice Maidas mentioned, we have conducted so far around 390,000 video conferencing hearings with a success rate of 87.75% and have released around 31,703 qualified PDLs because of video conferencing. So the numbers are very impressive. And this just shows not only the ease of use of the technology, but the increase of access to justice through technology. We understand that there might be some platforms that are more convenient or where others are more familiar with, but we need to strike the balance of ease of use on one hand and security and privacy on the other. In any case, as we continue to move forward with our digital transformation journey, We have to make sure that we will be able to properly manage these assets and resources, optimize risks, align strategies, measure performance, and value the service we are delivering. That's why the court is now formulating its own modern enterprise information governance framework. We also have to make sure that all our employees and stakeholders are fully aware of the changes that are brought by the digital transformation, and they are able to adapt to these changes. A change management program will be put in place soon and will be regularly reviewed to make sure that we don't leave anyone behind. We'll also be focusing on trainings on ICT and cybersecurity, as digital technologies will continue to play a crucial role in the decades to come. As we have mentioned, we are now discussing utilizing AI for several scenarios or use cases. And therefore, we have to start training and equipping all our personnel, both technical and non-technical, with up-to-date skill sets on ICT literacy and awareness, develop a culture of cybersecurity to make sure that we can truly be resilient and be able to pivot quickly and adopt modern ways of work using modern technologies. We want to make sure that every citizen will be able to access justice, not only through the traditional methods, but also through technological advancements. Imagine the public being able to file pleadings online while you are in a car or while you're on a vacation in Boracay. Having able to pay court fees, like paying or checking out your cart on Amazon, Shopee, or Lazada. Having able to monitor the status of your cases, like monitoring the status of your Facebook or Instagram posts. And eventually, having AI assist legal practitioners on legal research, like how Siri, Cortana, or Google Assistant assist us in making phone calls or in crafting text messages. All these, what we call technology for justice, are doable and achievable. And we aim to do so during the term of Chief Justice Alexander Desmundo. So we encourage all of you to join us in pursuing these projects, whether by submitting proposals, joining bids, providing feedbacks, or even better, join the judiciary in serving the Filipino people in advancing the rule of law. Thank you very much.
Thank you so much for all the updates and insights you have shared. Now it's time to hear our audience questions. And I see that there's a good number of questions being asked in our Q&A box. And probably for the first question, I will be addressing this to, for Judge Montesa. One question in the chat box is, taking into consideration the pros and cons of online hearing, do you think that this online hearing should still be carried on or still be implemented even after pandemic? Or do you think that we need to rule it out after the pandemic? Judge Montesa?
Yes, I believe that even after the pandemic, this video conferencing option should still be given to the parties. Remember that we may not be geographically be near each other always. So this particular option that can be given to parties will speed up the process. Remember, during trials, sometimes your witnesses may be coming from another province or another region, and that sometimes become or hampers the cases, and it usually gets postponed. But if parties are given this option of video conferencing, then even if your witnesses are remote, or even maybe lawyers who may be stranded in another place, can proceed with the hearings of this case. So I believe this could be of use to the courts even after the pandemic.
All right, thank you, Judge Montesa. Another question, and this one I think is for Justice Marquez. Do you think video conference hearings would help in speeding up court processes, and thus you see it being adopted permanently in our rules of court?
Well, thank you for that question. That's actually couched in a different way, but same question to Judge Nelda. No? Yes, like what Judge Montesa said, I believe that video conferencing hearings will be used even after the pandemic. No, In fact, the Supreme Court already came out with the guidelines institutionalizing video conferencing hearings. And I think that took effect January 16, 2021, if I'm not mistaken. No? In those guidelines, another interesting innovation or initiative there is that we can already receive testimonies from witnesses abroad, no? Provided that they will be testifying from our embassies or consulates. No? And this is not only limited to Filipino citizens, but also foreign nationals. No? So the idea there is, let's say, if there's a tourist who is in the Philippines for a short vacation, say 1 week, no? And then during that 1 week period, he gets involved in some case, no? Like let's say he was his cell phone was stolen or whatever case, no? He can pursue that case even after he has left the country, provided he will be appearing before our embassies or consulates in the country where he's going to be. No? Unfortunately, that process or that innovation, that initiative, no, has been suspended because our Department of Foreign Affairs, no, is still trying to do some processes and maybe informing or our embassies, our foreign service posts, no? Of this initiative from the court. No? So it was suspended until June 30, but with my recent meeting with the DFA, they will be seeking another extension of the suspension. But hopefully soon we will be able to use that facility. No? In fact, before it was suspended, we have already monitored a few hearings where the witnesses were appearing from abroad. No? And it was successful. No? In fact, some of those cases were already terminated because the witness or some of the parties were able to testify from abroad. No? So even after the pandemic, I think we will see these online hearings, and we will be improving, no, on these online hearings because we'll be using better equipment. And of course, we foresee, at least in our country, better connectivity, no, for our virtual hearings.
All right. Thank you, Justice Marquez. Another question that's in the Q&A box, I think this can be answered by Attorney Valderrama, especially that there's a lot of digitization within the law practitioner. So a lot of information is now being exchanged over the internet. How do our law practitioner deal and safeguard sensitive data they now conveniently have?
Okay. Yes.
Go ahead, Attorney Valderrama.
It is the usual question about with respect to the data as well as the security of the data in the platform. For example, they are always talking to me that there's always danger of being hacked. There's no such thing as 100% hack-proof because even the most secured platform in the USA, the CIA as well as Department of National Defense of the US is also vulnerable to hacking. And but of course, for us platform, we always put some safeguards with respect to against this hacking. No? So one of the example that I have to give you is that an online platform should have at least an SSL or secure socket layer, and you could find it in if there's an SSL, you can see the URL of the website. If there's a padlock icon in there, it means there is an encryption there, so it is safe. So usually we put there 128-bit up to 258-bit of cryptographic key in order to secure and protect it from hacking. And of course, the usual best practices in coding, as well as checking open packets and vulnerability assessment of the website. That's usually our duty to protect the platform against hacking or unlawful intrusion to safeguard the data of our platform. So as we are always saying, we cannot 100% assure you that we cannot be hacked, but we are doing our best, including all of our best practices to prevent the hacking.
All right. Thank you, Attorney Valderrama. Another question. This time, I think it's for Attorney Uy. Because of our current situation, legal practice is deviating from its traditional way in order to fit in our present technology. And since technology is fast, it is safe to say that the greater public can access justice fast as well. But how can technology in legal practice help those in accessing fair justice if they do have access to the internet, or probably limited access to the internet?
Okay, as we have mentioned, we want to make sure that every citizen will be able to access justice, not only through the traditional methods, but also through technological advancements. We understand that there are limitations at present in our infrastructure, and that is one of the priority areas of the current Chief Justice, to establish the ICT infrastructure of the judiciary. You'll be happy to know that soon we'll be providing free Wi-Fis in partnership, of course, with the executive department, in establishing these networks in our halls of justice to allow litigants and practitioners who may have limited access to the internet or technology at their homes, so that they're able to access justice through technological means. Second, we're also working hand in hand with DICT, DOJ, and DILG under the Justice Sector Coordinating Council umbrella. One of the areas or working group is on ICT and infrastructure. There have been plans to interconnect all of the systems of the judiciary, the executive department, especially those within the criminal justice sector. So the end goal is that once an information is filed by the prosecutor, it will automatically be transmitted to the e-court system that the courts are using. And once court resolution or other issuances or court issuances are made electronically, this will be received by our criminal justice agencies so that they can immediately be implemented. So these are some of the programs, although we understand, despite the limitations, that we will continue to work forward and make sure that we'll be able to expand justice not only through the traditional methods, but also through technological means.
All right, thank you. Another question that was pre-submitted, and this one is for Justice Marquez. What sort of policy change do you think are needed to support lawyers, the trial courts, and party litigants who are most vulnerable in fulfilling their obligations to justice and the public during this time? Justice Marquez.
Yes, thank you. Well, I think for lawyers, especially those in litigation or in the practice of law, they will have to keep themselves abreast with the latest technological innovations. As mentioned by Attorney Uy, we are not doing away with manual processes, but if the lawyer, especially lawyer appearing for a client, or representing a client, is abreast with the latest technological innovations, then he or she can serve his or her client better and faster. Because that's where we're going. In fact, even the Supreme Court, we continue to grapple with the latest technological innovations. No? You must remember that our the justices of the court are not also very young. No? They are seniors, and yet they have to learn and keep themselves aware and informed, no, of these latest innovations. So I think our lawyers, of course, our judges will have to follow suit. No? So this is really the way forward, and I think we just have to adjust with the changing times.
Thank you, Justice Marquez. Another question for Judge Montesa. There are other forms of dispute resolution aside from court litigation. Do you think lawyers should consider other dispute resolution forums other than the courts to help their clients resolve issues during this time? For example, online mediation, perhaps? Judge
Right.
Montesa?
Just to answer that, yes. Just to answer that, I think, of course, ADR is always part of our system, the alternative modes of dispute resolution. And I think lawyers should, of course, explore that possibility if it is available. Online mediation, I'm not sure if we already have that. Of course, there is, of course, with the courts, there are judicial dispute resolutions. There are, of course, with the lawyers, there are arbitration processes. So I think that should be explored if parties are amenable or willing to sit down on the table and explore the possibility of an alternative mode of resolving their dispute. That should be encouraged as well.
Thank you, Judge Montesa. Another question, possibly for Justice Marquez or Attorney Uy. Does the Supreme Court have plans on a one-stop shop electronic app for all legal services involving courts?
Maybe Sherwin can answer that. No?
Thank you, Justice Midas. Yeah, certainly. In fact, the one-stop electronic app or system would be the eCourt version 2.0. No? In the eCourt version 2.0, it will cover all procedures, whether it be from the rules of court or those covered by the specialized rules, covering the time a case is filed up to the time that a case is decided and the judgment is executed. This will also cover the monitoring of cases, the progression of cases, the different case incidents, as well as the verification of public documents, of court documents. So there will be a facility that will be made available so that the public will be able to do so. And we'll also be including the use of digital signatures. Eventually, we will allow not only court officers, but also perhaps the lawyers, the litigants, to sign documents electronically through the eCourt version 2.
All right. Thank you, Attorney Uy. This one question here is very interesting, and this is addressed for Judge Montesa. The question is, for judges, how will you determine if the witness is telling the truth with regard to his or her demeanor through online? Since we all know internet is not stable and judges cannot see face-to-face the demeanor of the witness. Judge Montesa?
Well, that is actually really a challenge, because sometimes you just see the forehead or the eyes, or just, it's quite difficult to, that's one of the difficult parts of an online hearing. But in answering the question of whether would you be believing the testimony of an accused because you don't see his or her demeanor, then maybe if you're an experienced judge, or maybe you're just sitting for the first time, you don't necessarily have to see the actual demeanor. You just have to listen to the testimony, look at how he or she answers, maybe ask the witness to, put away his phone a bit so that you can see the face, because you can't see the entire body, not like in a face-to-face hearing. But at the end of the day, the credibility of a witness, or the question of whether is he or she telling the truth, would come at the end, where you will be able to assess the story or the testimony that is actually given. So demeanor is just a part of assessing the credibility of a witness. So I think there are other ways and means for a judge to actually appreciate whether a witness is telling the truth or not. And if maybe during the online hearing you're convinced that he's not telling the truth, then the judge can intervene and ask clarificatory answers to just test his or her credibility.
May I add something, Attorney Mike?
Sure.
Yeah. I just like to add something to what Judge Nelda has said. Yes, of course, it can sometimes be quite difficult for the judge to determine the credibility of a witness, no, in an online hearing. So, if the judge is entertaining doubts, no, the judge can always suspend the hearing and reset it for an in-court hearing. There's no question on that. So we're just doing online hearings or virtual hearings to facilitate, no, to expedite our processes. But if it will affect the credibility or of the witnesses, no, whether and it will take a toll on whether the conviction or acquittal of an accused, then by all means, please, the judges are supposed to suspend that hearing and revert to manual in-court hearings.
Thank you, Justice Marquez. Another question for Attorney Uy. The question goes, I was wondering whether there will be plans on creating a PACER-like electronic platform. PACER means Public Access to Court Electronic Records, for the purpose of lessening physical dockets, more access to justice, fairness, and truth, and freedom of information. Attorney Uy?
Yes, actually, the end goal of the digital transformation of the court is to proceed with a technology-driven and paperless judiciary. Of course, if you're able to achieve that goal, we would provide the public with a facility to access court records online. Of course, subject to certain conditions and safeguards. And that despite them being public records or court records, it doesn't mean that it can immediately be made accessible by anyone. No? We also have to comply with the provisions of the data privacy law, as well as other data privacy rules and regulations issued by the National Privacy Commission. The last we want is for the court itself to violate these laws and rules while affording open access to court records.
All right, thank you, Attorney Uy. Another question, this time for Attorney Valderrama. How do you think individual law firms or lawyers can support the most vulnerable in having ready access to justice during this time? Is there anything they should consider doing differently in order to meet the unprecedented challenges of the COVID-19? Attorney Valderrama?
Well, we have to innovate and probably provide other indigent clients as well as the vulnerable sectors access to justice. So one of the projects that we are doing is the pro bono platform in Lexmeet, wherein we will be accepting indigent clients for pre-online legal consultation with our volunteer lawyers. So those are the projects that we should do in order for us to offer a good services to the public, no. And of course, as a legal tech enthusiast, we should also help the public in getting affordable legal services. So we should think of other business model that would also be fair to the lawyer, but also fair to the clients and avoid expensive legal fees.
All right, thank you, Attorney Valderrama. We're almost on top of our time with just 5 minutes left and probably just one more question. And this is very interesting. As earlier mentioned by Attorney Valderrama, lawyers right now are being more imaginative in terms of promoting themselves, which includes TikTok lawyers advertising themselves via social media. And this question is basically for Justice Marquez, probably. Because lawyers, by tradition, are supposed not to really advertise themselves out there as part of the rules. With these changing times, will there be any updates on those rules?
Um, well, lawyering when you look at the definition of lawyering, no, in our jurisprudence, it is very broad. It's very broad, and we have a passive court, meaning if there is no case filed in court, then the court will not act on it. No? In fact, earlier over lunch, because earlier at 1 p.m. we had oath taking of the IBP officers, no, here in the Supreme Court. And over lunch, I was discussing this with one of the officers of the IBP. And I was asking the IBP about it, no, exactly TikTok lawyers and those doing online consultations. No? I was asking the IBP officer if the IBP is doing something about it, no? Because this is really something very new and something that we cannot all be certain, no? Because some of those, according to him, no, appearing online are not exactly lawyers. No? So I think the Supreme Court, and the IBP will have to work on this together. No? If we want to come up with new rules regarding TikTok and online lawyers. No? I think, well, of course, if there are some violations, no, which are being done online, no, and there's a complainant, right away the court can act on it. No, but if there are no complainants, then I think this is something that we will have to sit down with the IBP.
All right, thank you, Justice Marquez. And time does fly so fast, but before we end today's webinar, I would like to ask our panel members if they have any final note for our audience. Let's start with Justice Marquez.
Well, I've said it earlier, no, in answering one of the questions. I think the lawyers, of course, including our judges, will have to keep themselves, no, abreast with the latest technological innovations, because the Supreme Court, no, is really on that path already, no, and we will have, and the judges and the lawyers will just have to keep pace, no, with what the Supreme Court is initiating. Thank you.
Thank you, Justice Marquez. Judge Montesa, any final note?
Yes, in response to my boss's statement, the judges are ready to embrace technological change. I think there is no turning back. We are in this together, even for the lawyers as well and all the stakeholders. And I think the trial courts are very much willing and ready to face the future with these technological advances. Thank you.
Thank you, Judge Montesa. Attorney Valderrama, any last notes?
The mantra for today is always getting ready. You know, the court, the lawyers, the litigants, and all the stakeholders in the legal profession in the judiciary system. And I think the way moving forward is for us to help one another to get ready with this kind of challenges, and as one nation we could move forward and have a better judiciary and innovative judiciary and innovative legal profession in the Philippines.
Thank you, Attorney Valderrama. And last but not the least, Attorney Uy.
Hi. Well, first, let me take this opportunity to thank again LexisNexis and Reed Elsevier, and to congratulate you for a successful webinar. This highlights our collective commitment to optimize and maximize the use of technology for justice. I hope to see more forums like this where we can debate, discuss, and explore how we can continue harnessing the limitless potential of technology, especially in access to justice. Thank you very much, everyone, and stay safe.
Thank you, Attorney. And yes, we are very much interested in doing future collaborations with you. Again, a special thank you to our panel members for sharing their knowledge, insights, and time on today's topic. And with that, ladies and gentlemen, we would like to thank each and every one of you for taking time to join today's webinar. And I hope you will join us again in future Rule of Law Cafe programs. Please do not forget to visit our Rule of Law Foundation website at www.lexisnexusrolfoundation.org or simply Google LexisNexis Rule of Law Foundation. There, you will see the different rule of law projects that the foundation has initiated across the globe. And it's also an area where you can connect with us on possible rule of law collaborations for the Philippines. Also, if you are interested to help advance the rule of law and be part of a company that values what matters, we encourage you to visit our website at www.readelsevier.com.ph or follow our social media accounts named Read Elsevier Philippines. Lastly, for those who registered, please expect an email from us in the next couple of days, which will contain electronic certificate of your attendance in today's Rule of Law Cafe webinar. Again, thank you and have a wonderful rest of your day. Bye-bye.